Hello, everybody. Welcome to UA Spotlight. I am here. I'm Will Ricciardella. Obviously, you can see my little decal there. Google's really stepping it up a notch, giving us decals. I have with us a special guest, uh, author and lawyer Adam Freedman, who wrote two books. One, The Naked Constitution, excellent book. If you want to get into the Constitution and you want to understand what the original meaning was, I really suggest you read that book. Also, our Republican Constitution. Geez, that's Randy Barnett's book. Sorry. A Less Perfect Union. I have it over there somewhere, which is a book on states' rights, and it's also a great book because you bring up a lot of history, and not just what the Constitution or the law means, but you bring up a lot of history about the Civil War, and I think that's important for libertarians to know, specifically about states' rights and how the North was really rebelling against the South and the federal government when it comes to the Fugitive Slave Acts. But first, I wanted to talk about Obergefell. A lot of libertarians see this as a decision predicated on freedom, that you do have this right to marriage, and that marriage laws before were largely discriminatory, and it was infringing on the rights of same-sex couples to get married. And I think a lot of the confusion stems from how they decided the case. Was Obergefell decided on the equal protection clause, that they were being denied some right that heterosexual couples were privy to?
Hi, Will. Thanks for having me on. Obergefell was not, the majority's decision was not an equal protection decision. It was more a, there's my book. Thank you very much, Will.
Yeah. Mm-hmm.
It was really a due process decision where the court held, and there's been this jurisprudence that maybe we'll get into a little bit more, but the 14th Amendment guarantees protect citizens against state laws that deny life, liberty, or property without due process of law. And so the concept of liberty rights has been expanded, so the courts have poured all kinds of things into liberties, which become rights that initially rights that are enumerated in other parts of the Constitution, and then ultimately the due process clause has been used as a vehicle to protect other rights that the Supreme Court deems to be fundamental. And so
does that largely give them carte blanche to say whatever that they can write into the law, whatever they see fit as a right, just via jurisprudence?
Yeah, that's exactly right. Well, and I think especially if any of our listeners out there, if any of your listeners are libertarians, I understand that there's an argument for recognizing same-sex unions, but that's different from saying that the Constitution requires states to recognize same-sex unions, which is what Obergefell does. There's this myth that Obergefell legalized gay marriage. It didn't legalize it. It required it. It mandated it. It gave states no choice by constitutionalizing it. And so, yes, the 14th Amendment's due process clause has become a kind of blank slate for judicial legislation.
And just to clarify for the viewers, the due process clause, they're reading into the due process clause a fundamental rights doctrine, so to speak, right? They're saying that your due process rights are being violated by the states not allowing you this fundamental right to marriage, that you're being denied or disparaged a certain right without due process of law to a degree.
That's correct. They're reading in a fundamental rights analysis, and this is nothing new. The Obergefell court didn't invent that approach. The courts have been using it for decades, but this is yet another expansion of it, because the idea of the fundamental rights doctrine originally was that the court would uphold against due process challenge certain rights that were deemed to be of such long-standing importance to Americans that we can somehow assume that the due process clause was meant to protect them. I think it's obvious that same-sex marriage, whatever its merits, is not a long-standing fundamental right in American history.
Hmm. And then a lot of libertarians will say, well, government should stay out of the marriage business, that it's not the business of government to be recognizing or offering marriage licenses. But isn't there a discernible purpose for marriage law, or a body of marriage law? And furthermore, aren't people voluntarily interjecting government into their marriages as a third party through marriage law?
Yeah, I think that it's a very different debate, and so the, the there's nothing libertarian about the Obergefell decision, right? Because it just mandates yet more government benefits to a new class of people who will for henceforth be deemed to be married in the eyes of the government. Uh, the the government the government writ large will never, I think, be completely out of the business of marriage, because if nothing else, even if you didn't have state marriage licenses, the courts, which are instruments of the state, would have to decide who's married and who's not in the context of, for example, people who die without a will, people who are dividing property upon a divorce. Well, how do you know there's a divorce? Well, there has to have been a marriage. And so courts will be sorting that out. And so I think that there is a prudent reason for government to recognize marriage. Another question is whether there's a good policy reason for governments to subsidize marriage with certain benefits and tax breaks and things that people who are not married have to subsidize. And that's a very different decision.
So essentially, what it is that the Obergefell decision, really being anti-libertarian, is that it took away the states' rights of self-government to determine whether they want to have or whether they want to recognize same-sex unions and offer them those benefits via a contract. Take this body of law that has been applied to generally heterosexual couples for however long, and then apply it to same-sex couples. And the people of the states, that generally the people that enforce those contracts, they took the decision out of their hands by declaring it a fundamental right. So really, you can look at it as kind of an assault on local self-government.
Absolutely, and that's really that's the real tragedy of Obergefell. I think that you can debate about whether or not same-sex marriage is a fundamental right, but self-government is clearly at the heart of our federalist system. The idea that communities and states are individual bodies politic with the right to determine these kind of internal affairs that don't really extend beyond their boundary. I mean, a state can recognize, and for centuries, states have set marriage laws. And so when we're in the middle of a very active national debate about what marriage means, with referenda and ballot initiatives and state elections, suddenly the Supreme Court stepped in and said, that's enough of this debate and legislation. We're going to decide a policy for the entire country. 9 unelected justices. Well, really 5 unelected justices who made that decision.
Yeah, absolutely. 5 to 4 votes. So one justice swinging either way determines what our rights are, which is kind of a scary thing. I mean, I think the whole point of government was to protect our already existing rights, not create new ones. And I don't think that you have any sort of right to a government contract. Essentially, that's what it is. It's an economic arrangement between a man and a woman to protect one person's investment against the other. And like you said, it has to do with contracts, and the courts will have to sort that out. People change their lifestyles when they enter into these relationships. Most notably, and throughout history, it's really been the woman that has really changed their relationship, because they invest more in the family, as it means by having kids, right? I mean, and this economic contract protected her investment. And I always say that marriage law really restricts your rights. It's not really granting any rights. It's that I can't just up and leave my relationship without incurring certain costs. I just can't come and go as I please. There are certain things I cannot do. And in California specifically, if I buy a car or a house, and just myself, and with just my name on the title, 50% of it, would legally belong to my spouse. So, I mean, this is really an economic arrangement, and these laws were promulgated over time. It wasn't just something that some bigot 100 years ago said, hey, let's make sure that we recognize marriage so that we can, exclude same-sex couples.
Right. I think that's a very important point, Will. There is one of the themes of the court's decision in Obergefell, and then earlier in the Defense of Marriage Act, the Windsor decisions, is this idea that traditional marriage laws are motivated by bigotry.
And Windsor was the DOMA case, correct? Just so
Yeah,
everybody.
Windsor was the DOMA case. Yeah. So, and I think that that's a really harmful way of approaching the question, and unfair and untrue. As you said, when these marriage laws are a very long-standing vintage, and nobody thought at the time that there was a same-sex marriage out there to be excluded. That was not part of the equation. The idea was really, as you say, I mean, a lot of it was to protect women. It's really to traditionally to bind men to their offspring, and to encourage offspring in a civilizing structure. Now, having said that, of course, many same-sex couples, and I know many of them, are wonderful people and committed to each other, and I think that with or without Obergefell, states would recognize equitable distribution of their assets if they split up, because one person may be paying for the mortgage of the other person, and so this isn't really about them so much. But what I think is unfortunate is that with the state taking the lead in the idea that marriage is really characterized by an emotional union that can be of greater or lesser intensity, it's really going to weaken marriage among the more vulnerable classes, in the working class and inner city type environments, where there is often less and less incentive for the man to stick around.
So what you're saying is, on the conjugal view, you're saying that it's not just an emotional connection. It's not just about love. It's really about the difference between a heterosexual and homosexual couple. That a heterosexual couple, when they engage in sex acts, it's for procreative purposes. It's that there's a discernible purpose to the act, and as opposed to same-sex couples where it's mainly behavioral, that there will be no outcome. I mean, and you're saying that you're reducing marriage to just this emotional love connection, that it really has little to do with the act itself of procreation, and just to do with, I have an emotional connection to this other person, therefore I should be afforded a contract with a body of law that doesn't apply to that same type of relationship.
Right. Well, I think that's a very serious point, and I'm not an expert on marriage, but what I think is that this is one of the unknowns about the new world we live in, where same-sex marriage is a fundamental right on par with traditional opposite-sex marriage. And so I don't know if I'm right about that, but I know that the Supreme Court doesn't know the answer to that either.
Mm-hmm.
And to make a decision, a fundamental cultural decision like that, through the courts, rather than through the democratic process evolving state by state over the years, with different communities being able to see what happens in other communities when these kinds of laws take effect, is absolutely wrong. It should have been handled. This is precisely the kind of domestic issue that was meant to be handled through the democratic process in an evolutionary way.
Right. I mean, kind of this, it happens organically, and it was happening organically. I believe 13 or 14 states, by the time when they had this ruling, had already recognized same-sex marriage. And I mean, I would have voted for it in my own state. I'm kind of ticked off that the Supreme Court took away, my ability, my sovereignty to decide whether or not here in California, which actually rejected it twice, would like to recognize same-sex marriage. I'm sure by now people would have voted for it. I like it only that it lowers taxes, that people of the same sex can get together and get tax benefits, and that's less money for the government. So I can appreciate that. But even without, I mean, the thing is that marriage existed before government, and that society dictated what marriage was. And that now you have one judge telling society, or changing the definition and telling society that you're denying rights, and you've been denying rights for 220 some years, and that you've largely been bigoted since the beginning of time, since whenever I think marriage is a 6,000-year-old institution, and that it's been bigoted this entire time, and that one enlightened justice can tell the American people that. And I think that's an awful lot of power for one judge to have.
Yeah, well, you're absolutely right. Marriage obviously predates the Constitution. It predates government. It has existed for as long as civilization has existed. And when you talk about one justice, it's obviously Anthony Kennedy who wrote the sole opinion. And I think that the assumption is that his the price he extracted from the liberal justices to give them his vote was that he was going to be the sole author of that opinion. Because I think that what Anthony Kennedy wants is to go down in history as you know, a kind of you know,
A god?
Earl Warren kind of figure in Supreme Court history. And the unfortunate thing about, for the people who forget that marriage is an institution that predates government, is that we now have the view that the government dispenses rights. The government doesn't dispense rights. Our rights exist. Rights come first, as Professor Barnett says in his recent book, and then comes government. Government is to secure rights that exist, whether or not the government exists.
That's correct. And I just want to remind everybody to buy your books. Again, this one is great, especially for the Civil War. A lot of libertarians disagree on that. This really clears it up succinctly. You also have an article on this, I think, on the City Journal too.
That's right.
You did a quick argument on like the main points of states' rights and how the North was using states' rights to you know, to protect runaway slaves, or and to kind of chip away at the institution of slavery. And the Naked Constitution. Also, these are easy to read books. They're well written, and you can learn more about constitutional law. And especially the Naked Constitution, you can learn about the administrative state and the steps it's taking to, you know, infringe on our liberties without any recourse from the body politic. Again, thank you, Adam Freedman, for coming. And our next show will be on the jurisprudence of the 14th Amendment and the original meaning of the 14th Amendment. We can get into the nuts and bolts a little bit for those that are more interested. But again, thank you for coming on, and we'll see you in a little bit.
Thanks, Phil.